Start. The Patna High Court held that oral evidence could be admissible to prove the contents of a document under Section 92 of the Indian Evidence Act if there is a claim about the misdescription of plot number in a sale deed stock. Justice Arun Kumar Jha was considering the petitioner's case against the order of Munsif Court, which did not permit the petitioner/plaintiff to cross-examine the respondent/defendant on the point of boundary contained in the sale deed stub. The petitioner/plaintiff had filed a suit for declaration of title on the suit land stub. The Munsif Court disallowed the petitioner from cross-examining the respondent/defendant regarding the boundary of plot numbers 659 and 654 on the ground that oral evidence cannot be given to change or alter the contents of a document under Section 92 of the Indian Evidence Act stanza. The High Court examined the provisions of Sections 91 and 92 of the Indian Evidence Act Section 91 provides that the terms of a document must be proved by either the document itself or by secondary evidence. Section 92 provides that when the terms of the document have been proved under Section 91, no oral evidence can be admitted to disprove the terms of the document except under certain conditions. The court noted that these provisions are supplementing to each other and that Section 91 applies to all documents whether they purport to dispose of rights or not, whereas Section 92 applies to documents which can be described as disposing of right. It stated that these provisions are based on the best evidence rule, which means that when superior evidence is available, inferior evidence cannot be considered. When a transaction has been reduced to writing, it becomes the exclusive evidence, and therefore internal evidence cannot be produced to contradict or vary the terms of the document. The provisions of the aforesaid two sections are based on best evidence rule that when a transaction has been reduced to writing, it becomes the exclusive memorial thereof, and no external evidence is admissible either to prove independently the transaction or to contradict, vary, add to or subtract from the terms of the documents, though the content of the document may be proved either by primary or secondary evidence. The law always requires that only the best evidence be laid, and hence to admit inferior evidence when the law requires superior would be to nullify the law. The courts